from a legal standpoint, son of Sam laws. It's a term that's been thrown around, um, related to people that are convicted, profiting off their crimes. Explain to people, though, what are son of Sam laws, and does Virginia have a son of Sam law?
Son of Sam laws prohibit criminals from profiting from writings or shows or movies or cinema about their crimes. However, courts have frequently struck down these laws on First Amendment grounds. Now, the Son of Sam laws first came about out of New York because of the convicted serial killer in 1977, David Berkowitz, who was known as Son of Sam. He sold his exclusive rights and story rights, his exclusive story rights to a publisher. And this was challenged by the publisher it was sold to. It was challenged in the court, Simon and Schuster. Lawsuit was filed against them by the New York State Crime Victims Board and the U.S. District Court of New York. And between the district court and the appeals court, they ruled in favor of the Son of Sam laws. However, the U.S. Supreme Court in 1991, in Simon and Schuster versus members of the New York State Crime Board, Victims Board, the Supreme Court declared that the statute was unconstitutional based upon what's called content-based restriction of speech for two reasons, being over-inclusive and also under-inclusive. Other states have enacted very similar Son of Sam laws with various restrictions as relates to the U.S. Supreme Court itself. Here in the Commonwealth of Virginia, our Son of Sam law, or can be interpreted as such, is under what we call the Special Order of Escrow. The Special Order of Escrow states, very similar to the Son of Sam law, it prevents any proceeds or profits received or to be received directly or indirectly, except for property that may be forfeited to the Commonwealth, by any defendant as a direct or indirect result of his or her crime or sentence or the notoriety which such crime or sentence has conferred upon them. That shall be subject to escrow itself.
And with that Virginia law, so that basically states that someone convicted of a crime can't make money directly or indirectly off the crime that they've been convicted of, whether that's through literary works, through film or television. But or what items would you say are covered under this law?
Now, again, the law itself here in the Commonwealth actually is drafted to be congruent with the Supreme Court ruling. So in subsection B of the statute, any proceeds from a contract relating to a depiction or discussion of the defendant's crime in a movie, book, or like shall not be subject to special order of escrow unless there's an integral part of the work is a depiction or discussion of the defendant's crime or an impression of the defendant's thoughts, opinions, and emotions of such crime. So that would have to go through a discovery and a close look at that particular work of art to determine if, in fact, it should be subject to order of escrow.
I was going to say, Eric, if you don't mind, also too, from a layperson standpoint, because this is, a lot to digest, but what is it in Virginia that people that have been convicted can and can't do when it comes to profiting off their crimes?
Well, for example, those individuals that are convicted of those crimes, those felonies, they probably cannot, and again, this is an interpretation of the statute, and it takes a court to make a final determination. But more than likely, they will not be able to profit off their own words or their own impression or thoughts or opinions of such crimes. So if they act as a special consultant on the actual literary work, and they give their information about what took place and their thoughts about it and their emotions about it, they probably will not be able to profit from that, according to the statute. But again, that would have to be a determination of the court.
So according to this statute of Virginia law, where would the money go? Does it go to the state, or does it say exactly where the money would go?
Well, actually it does. So therefore, upon petition by the attorney for the Commonwealth, a petition can be filed in the jurisdiction, of course, where the person was convicted, and that money will go in a special escrow or what's called interested parties. And those are the victims of that particular crime.
Got it. So the money would go to through the state to the victims that of this crime.
Yes, that is correct.
Gotcha. Thank you very much for explaining all of that. So we're talking murderabilia here. We've seen letters, paintings, prison ID cards. A lot of the stuff is maybe not tied directly to the convicted person. It's maybe someone a third party. Would murderabilia or items that are considered murderabilia by some be covered under this law as to the money would have to be forfeited back to the state?
Well, first of all, let's look at what murderabilia is. Murderabilia is a term that really identifies the collectibles related to murderers, homicides, and the perpetuators of those or other violent crimes. As it relates to these items being attached to the Son of Sam laws, it will be a stretch because they are not related to the actual crime that took place, but rather personal property of that person. So let's just say, case in point, someone who is a convicted felon of a murder wrote a letter, a general letter to someone, not about the crime that what they were convicted of, just a general letter. Would that letter be subject to Son of Sam laws? Based upon the interpretation of the actual statute, the answer is no. However, if they did write a letter, a depiction about the actual crime in which they committed, they went in detail, they gave their opinion, their emotions about it, then would that be connected to Son of Sam laws? If it was provided as a depiction in some type of literary work, a movie, something of that nature, then more than likely it would be subject to Son of Sam laws. But again, that becomes a determination of the court. But a general artifact not connected to the crime itself is more than likely that they would not be connected.
And this Virginia law, this applies directly to the convicted person. So this does not apply to, say, someone not directly. So this wouldn't apply to third parties that have these items that are trying to sell them either online or in person, correct?
Well, the statute provides by the defendant or a transferee of that defendant from any source. Now, more than likely, that is someone that probably has the power of attorney for that individual, or they've been given their exclusive rights over to that particular individual, that transferee. So, more than likely, the vendor for murderabilia would not be connected to or subject to these Son of Sam laws.
Gotcha. So, like John Smith were to acquire a prison ID card from Lee Boyd Malvo and is selling it on a website, that person wouldn't be they wouldn't have to forfeit that money as Virginia law states in that statute.
Based upon how the statute reads and based upon the definition of murderabilia, is very unlikely. However, one could file a petition and have the court make a determination.
Gotcha. And mainly, like you were saying too, the Son of Sam laws apply to literary works, so books, plays, and films, TV series. That's mainly what's covered under these Son of Sam laws, right?
You're right. Publications, radio, television productions, movies, newspapers, magazines, anything that is a literary work or can be turned into a literary work.
Gotcha. And is there anything else you'd like to add about any of this, or because we know that there's also some laws or legislation that was brought up by lawmakers within the last 10 years to try and put an end to murderabilia? Is there anything you want to comment from that standpoint?
Well, again, we do get into very sticky areas of First Amendment rights, property rights, and of course, rights and freedoms of individuals to have various businesses and also commerce. So even though these laws are in the right place from a victim's right standpoint, the Constitution itself, it looks as if when they are taken to the Supreme Court, it looks as if the court rules in favor of the First Amendment rights as a whole. So again, it's we don't know exactly what will happen in the future with the rulings as the court fluctuates, and it really just makes it's a determination of where the court is. But again, the laws in the court has been consistent since 1991, and since really 1989, 1991, and the original Son of Sam law being challenged.